name is Sandy Calalesina. I'm an agent with Century 21 Turner Brokers in Lakewood, and I'm here today with Andy Robinson Jr. from the law office of Andrew S. Robinson Jr., who's just started his new practice. So I'd like to introduce everybody to Andy.
I'm Kathy Sullivan from Century 21. Awesome.
And I know Sandy mentioned I just started my own practice. However, I have been practicing law for 21 years. But we're going to talk a little bit about what to expect as a first-time home buyer, what your attorney is going to do, and what the process is. So the first thing we wait for is a mortgage commitment from the bank. Once we receive the mortgage commitment, we forward that to the seller's attorney. The seller's attorney then orders an update of the title search, orders the survey, and once they receive that, they forward the updated title search and the survey with a proposed deed to my office for review. I then examine the title to make sure that there is a valid warranty deed going back at least 50 years and make sure that there's no defects in title. We also look to see that if there's any outstanding mortgages on the property, if there's any liens or judgments against the property that may encumber title. And
So it's pretty important that you do that background work to guarantee people have a
marketable
title for that property. Yeah.
That's correct. And if there are defects in title, then we insist that the seller cure those defects. If the title defects cannot be cured, then we insist that the seller purchase an owner's policy of title insurance that would ensure your interest in title to the property. What I mean by that is if there was ever an issue, if someone came forward and objected to your title or ownership in the property, then the title company would provide you with a legal defense, and it may indemnify you against any loss. It would depend on the policy. But the other reason for examining title is ordering a lender's policy of title insurance, because anytime you have a mortgage, the bank requires that you purchase a lender's policy of title insurance that ensures the bank's interest in title to the property. We're ensuring that you're getting a marketable title to the property. We also have to be able to order a lender's policy of title insurance to ensure the bank's interest in title to the property. And then we may be ordering an owner's policy of title insurance depending on if there's defects in title, or you always have the option of purchasing an owner's policy of title insurance at an additional cost to you, but that's optional.
We always talk about marketable title, and I think we're dealing with the new buyers. I don't know really, what does marketable mean to a new buyer?
Well, a marketable title basically means a title that's free and clear of any defects, liens, judgments, stuff that would be an impediment to you transferring title.
Yes, that sounds pretty important. It also sounds very complicated. I mean, there's a lot of things that an attorney does that I don't think just the average person understands. That's very, very important for somebody taking possession of a property. So.
Right, yeah. And one of the other things we do is the title search will always certify to a deed where they say this is the language that should be used on the deed. So when we get the proposed deed from the seller's attorney, we always compare that to the deed that the title is certified to make sure that it has all the proper language in there, because if there's one minor mistake, it can make a huge difference in the size of a lot or other things, and that can cause impediments to title that have to be cured down the line. So it is important.
Now, when you're talking about the survey, are there issues that you're looking for specifically, or things that can come up that a buyer should be concerned about, or things that you'll be warning them?
Yes. One of the things with survey, we want to make sure that, first of all, the property is what you have contracted to buy. We also make sure that we check all the boundary lines and make sure that there's no encroachments, meaning that the neighbor's shed isn't encroaching onto your property, the neighbor's fence wasn't built on your property, or to make sure that the shed on the property you're buying isn't encroaching onto the neighbor's land.
And if those things come up, how are those usually handled?
It depends on the situation. Most sheds are on skids, they can be moved, fences can always be moved. Where it becomes more of an issue is if you find that the garage or a structure is actually encroaching, then that can be an issue. Usually that is cured through an owner's policy of title insurance, where the title company says, look, we will insure your title and interest to the land, and if there's ever an issue with the neighbor complaining or suing about the garage encroaching, we provide you with legal defense for that. That's what the title company does. When you do purchase a title policy, whether it be a lender's policy or an owner's policy, it's a one-time premium. So you pay the premium once, and then the insurance is in place for so long as you own the property.
But they don't, are lot lines ever adjusted, or do they make changes to survey stakes or stuff at the actual maps, or do they just handle that with the title insurance?
It generally, no, the boundary markers, boundary lines are what the boundary lines are. Sometimes you will find where a mistake has been made on a prior survey, and the lot may be different than what was depicted on the survey that you had, or the description the surveyor gave, the legal description of the property may be a bit off. I did run into that situation just recently. It took quite a bit of deed work and some legal gymnastics to get that all squared away, but it's rare that you see an issue like that pop up, but they do come up. I have seen them come up.
Yeah, it's a lot of extra study and work. Do you ever do an easement over somebody's property?
Yes, that's another option. If you do find, if it is discovered that your garage is encroaching onto the neighbor's property, that's another option to approach the neighbor and ask for an easement, where the neighbor will allow the garage to remain in its present location, unless and until it's going to be replaced or repaired. Then it would have to be moved back over onto your property.
But that's all got to be done very legally,
right.
I would imagine.
Right.
To ensure that's
right. That involves drawing up an encroachment agreement and then filing that with the deed work when everything gets recorded.
Yeah.
Once the title search is ordered and we see that, and we approve the deed, and we find that there aren't any defects in title, then we'll order the lender's policy of title insurance, and then we will schedule it for a closing. The seller's attorney then has the seller sign all of the transfer documents that are required, and then they provide those to us, and then we schedule a closing with the bank where we sit down at the actual closing table. You then sign all of the bank documents, of course, the mortgage, the note, the myriad of other documents the banks have you sign. And then you also sign all the transfer documents that those are the ones that go up to Mayville to get recorded in the county clerk's office. There's always, everyone always thinks, well, I'm buying this house for $100,000, I have to come up with $100,000. Well, you know, there's always additional costs, there's bank fees, there's attorney's fees, there's closing costs involved, so oftentimes you actually have to come up with more funds than what you actually
Andy, could you go over the process of wells and septics and how that stuff's handled with the private water and wastewater that when people have purchased a home?
Yeah, sure. That comes into play a lot when someone buys a home outside of a city or a village where the sewer doesn't run or the water lines don't run out there. So there are a lot of homes in the country that are serviced by a well and a septic system. So if you are purchasing a home that has a well and or a septic system, then the seller must have the well and the septic system tested by the county health department. The county tests the water to make sure that it's potable water, that it's safe to drink. and they test the septic system they often do a dye test where they flush dye down the toilets, and they look to see if it's coming out of the leach field. They also need to make sure that the septic system is compliant with the current codes. So
how do they do that?
Well, I think they generally have records on properties of the type of system that's in place. I know I just found out recently I had an issue. I live in a home where we have city water, but the sewer doesn't run up to my home, so we have to have a septic system. And something went wrong with my septic system last summer. We had a contractor out. He has to speak with the county health department to tell him what the issue is and the repair he has to make, and get approval from the county before he can make that repair. I then found out that my septic system was no longer in compliance. It was in compliance when I purchased the home 9 years ago, but now it's no longer in compliance with the standards that they had in place. So I had to get a new septic system put in, but the contractor will make any remediation or repairs or replacement that the county is requiring. The seller is responsible for the cost of that unless you contract it otherwise. But under a typical contract, it's the seller who's responsible for making sure that the drinking water passes county health inspection and the septic system. Sometimes we run into an issue where you're purchasing a house during the winter time and the county health department can't test the septic during winter time. If the ground's frozen, they cannot test it. So we run into that situation a lot. They can still test the drinking water, but they can't test the septic until the ground, until it thaws, and they're able to do it generally in the spring. So what happens in those cases is we will draw up a separate escrow agreement where, as a purchaser's attorney, we would hold money in escrow that would normally go to the seller for the purchase price of the property, and we would hold those funds in escrow until the repairs are made.
What does escrow mean?
Escrow means that the escrow agent, which typically one of the attorneys acts as the escrow agent, they hold that money in their trust account
like
to
the
be
bank?
used. Correct. Yes, they hold it in trust until all the parties agree that it can be released. Oftentimes, those funds are used towards the cost of any repairs, remediation, or replacement.
And you, as the attorneys, decide how much is going to be held in escrow?
Yes. I know with the Jamestown Bar Association, we are talking about standardizing the amounts. Typically, it's approximately $10,000 for a septic system, and usually anywhere near right around $3,000 for a well.
Okay.
But the Bar Association is in the process of coming up with the standard numbers,
So
that everyone's
everybody's
aware of
going to
them
be
going
aware of
in. Correct.
the amount.
But if you are purchasing a home with a septic system or a well, those are all issues you should be aware of going into it.
Now, what about if the house happens to be vacant? Is there any issues with those tests?
Yes, because that's a good question. The house must be occupied for at least 30 days before the county can test the septic. The well water can be tested at any time, but it must be occupied for at least 30 days before the county will test it. So that can hold things up as well, and we usually have funds in escrow to address that type of situation.
So once again, you have to escrow that money until the county comes and tests it after 30
Correct,
days.
until it can be tested. And sometimes there's a delay. Sometimes you have to move into the property and actually use it for at least 30 days, and then the county will then come back out and test it.
And if it's winter, it would just obviously be the same length of time like it would if there had been somebody having the house.
Exactly. It's after we sit down at the closing table and all the documents are signed, all the bank documents, the mortgage, the note, all the transfer documents, I then, as a buyer's attorney, have the documents couriered up to Mayville to the title company. The title company then brings them over to the county clerk's office and puts them on record. Well, once they have that recording slip, they notify me, usually the agents and the seller's attorney, that it has gone on record. And at that point in time is usually when the keys are exchanged. It's not often that you get the keys at the closing table, because you don't legally own the property until everything is recorded up in Mayville, or at least the keys don't usually get exchanged until everything is recorded up in Mayville. And then the keys are exchanged. But that usually happens the same day. Most closings are scheduled in the morning or early afternoon. That gives us enough time to get everything couriered up to Mayville and to get everything on record. And then usually you have the keys by late afternoon or early evening of the day that you close.
It's good to let the buyers know that sometimes it's not going to be instantaneous, and they say, well, I paid the money, but it's not your house yet, is what we have to tell them. Okay.
There's another thing that's very important. As a buyer, you always have to have homeowners insurance in place before closing. You have to have that prior to closing. And when you go over the closing disclosure with the bank, if you're escrowing your taxes and your insurance with the bank, they collect for insurance. And a question I often get asked is, I just paid for insurance, why is the bank collecting for insurance? Well, in New York State, we pay our taxes and our insurance a year in advance. So the policy you purchase insures you for the first year that you own the property, but the bank will collect 1/12 of the insurance premium, so that the following year they can then pay the homeowner's insurance for the next year, and they have the money to pay all the taxes as well. So that's the way an escrow account works.
A lot to do, and we were very happy to leave it to an expert to do this, because we'd have no clue.
Well, there is a lot involved. New York State does things the old-fashioned way, and New York State tends to try to make things as difficult as possible, it seems, whenever they can. But
unfortunately.
But they do things the old-fashioned way. So I do get that question oftentimes from people out of state. They say, why is this taking so long? I know that in Ohio, some states are just title states where you sign a contract, everything goes to the title companies. The title companies issue title insurance, bing, bam, boom, you can close on it in 2 to 3 weeks. But again, New York does everything the old-fashioned way, so it is quite a process. But it is nice to have an attorney examine the title to look for defects in title, because you'd be surprised what shows up on some of these title reports.
Thank you very much. It's very good information. I think it will help.
Absolutely.
Help
Thanks,
us and
Andy.
help
Like I
buyers.
said, we'll leave it to the expert, and worked with Andy for a number of years, and I know his expertise is, we're very grateful for all he does.
Well, thank you. I try my best. I just
Yeah.
try to treat all my clients the way I'd want to be treated. So.
And you do. Thank you.
Okay. Thank you.